Mr. Kervin, are you challenging that? Are you saying you did have a valid license?
No, I had a question before that about the jurisdiction. I was challenging jurisdiction 'cause I had a question about that.
Okay.
'Cause I wanted to know the cause and nature of what's bringing the suit against you. So I really didn't understand.
All right. Well, the people of Kansas, as you probably know, get together ever so often and have elections to elect people to represent them in Topeka, the state capital, and those legislators pass laws that are for the good of all of us in theory, maybe in practice, and then we are to follow those laws. One of the laws at some point in time that those legislators made was that if we are going to operate a motor vehicle in Kansas, we have to have a valid driver's license. And if you do not have a valid driver's license when driving the automobile, it is to be treated as a Class B non-person misdemeanor. And they set the penalties of up to 6 months in the county jail and a $1,000 fine. So the authority comes from the.
This is yet another wild sovereign citizen courtroom case, where the entire hearing falls apart simply because the defendant refuses to recognize basic law. What begins as a normal session quickly turns into chaos. You'll see how this Kansas judge shows saint-like patience until he finally reaches his limit.
It's criminal. With that, it gives the court two ways. Sixth Amendment actually gives the court two ways to do it. They can do it through either common law or is it colorable maritime admiralty law. Which one am I want to be tried under? With jurisdiction?
This is neither common law nor admiralty law. This is criminal law under the Constitution of the state of Kansas, as affected by case law and federal law, of course.
So it's neither common nor color.
That is correct. That is correct.
So which one? What am I going to be tried under? What jurisdiction I fall under, so I can properly move and so I can understand how to defend myself?
You're being tried under the criminal jurisdiction of the Kansas statutes.
But
it all starts like a classic sovereign citizen defense. Instead of answering a simple question about having a valid license, the defendant immediately begins challenging the court's authority. The judge calmly explains that Kansas laws are created by elected officials, that driving without a license is a misdemeanor, and that this isn't some secret tribunal. It's just straightforward criminal law.
Compact, you consent to those laws when you enter into that state. So jurisdiction is set up, as the judge said, by the Constitution of the state of Kansas and the laws of the legislature that are passed statutorily, and our statutes are passed with the law in this case. I would note for the record, Judge, that there is still no things on Odyssey for me to see. There's not a written request for jury trial. There's no motions to be heard today. I cannot respond to any motions because there's none on file.
Well,
therefore, if
he
he is going to file anything of record for me to respond to, he would need to have his filings on file at least 7 days advance of a hearing for me to respond, and that there is no proper written request for a jury trial at this time. Therefore, this case could go to bench trial on Wednesday, and we would not have to have a jury present due to the fact that there is a lack of request for jury trial. And if there is no written request for jury trial, the case goes to bench trial.
But the defendant refuses to accept it. He keeps demanding to know if this is common law or admiralty law, two buzzwords taken straight from internet conspiracy forums. Judges hear this kind of thing all the time. It's not law. It's not valid. Yet the court still wastes valuable time going over the same nonsense again and again.
The conduct of going on to a road that is a state of Kansas highway and a
So which jurisdiction would be under? Like, would that be like maritime, like as a
Sir,
contract?
I've answered that question to you, and you got on the road, and you consented to driving on the road, and therefore you did consent to laws associated with driving. So I am going to hold you to the law in this particular case. Now,
what I'm understanding when you say the cause of nature, and but that's why I was not understanding still about that, because you said the cause of nature, and I had not asked.
Sir, if you want me to entertain any of your arguments, you need to have them well thought out, and you need to have them in writing, and you need to have them, sir, listen to me please, you need to have them in writing, need to have them filed with the court, you need to give copies and notice to Miss Gillette so she can have an opportunity to respond. And I'm not going to entertain this process throughout the proceedings where you come in and...
The prosecutor steps in here and makes a clear point. When you drive on public roads, you automatically agree to follow that state's laws. It's not a trick or hidden rule. It's just how the system works. You share the roads, you follow the rules. But this defendant doesn't want to hear that, even though legally, the prosecutor's argument is airtight.
Maybe you misunderstood what I was asking.
Please don't interrupt me.
I had a question.
Sir, stop and listen to me. If you want a jury trial, I will make sure you have a jury trial. If you want to represent, sir, stop interrupting me. If you want a jury trial, I will make sure you have a jury trial. If you want an attorney, I'll make sure you have an attorney to help you. But if you're going to do this on your own, you need to know what you're doing, and you need to follow the law just as an attorney would be expected to. But you're not going to come in here and just start saying things, and I'll answer questions as long as they're legitimate questions. So at this point, I'll ask you once again, are you sure you don't want an attorney to help you, someone who is trained in the law? Because this, sir, is a court of law, and if you don't have the...
By now, the judge's patience is wearing thin. He warns the defendant to stop bringing half-baked arguments from the internet. If he wants to challenge something, he needs to do it in writing. But instead, the defendant keeps circling around the same topic, ignoring court procedure and demanding impossible answers.
You're either... I'm not going to play games with you. I understand the sovereign citizen position that you take.
I'm not claiming, I didn't say anything about sovereign anything, ma'am. I'm asking how the right to defend myself. Under my Sixth Amendment right to know, I have right to know which jurisdiction are you going to try me under, and you're telling me in order to ask me for a lawyer, and I'm like, before I even go to trial, I like to know what jurisdiction am I falling up under, and you're telling me I have to find, in order to find out, I have to get a lawyer. So you're telling me for the record, the defendant has to get a lawyer because there's already some way only lawyers understand what jurisdiction or what I'm going to be tried under. So that's the only way I can know. Instead of you asking me, but you have the duty to tell me under the Sixth Amendment. Do you not?
Okay, now it's your turn to stop talking and my turn to talk. I have answered your questions. I've told you the jurisdiction. You don't like my answers, so you voice your objection for appeal and we move on. We're not going to keep playing this game, sir. Now, do you want a lawyer or do you not?
I need a lawyer for you to tell me. When I'm asking you, like, because you saying it's not in the criminal matter, so there's a hurt party.
Sir, quit repeating yourself.
If there's a hurt party, can you present the hurt party to me?
If you keep sitting here wanting to argue with the court, I may have to find you in contempt. Is that what you're trying to get me?
I'm not arguing about the court. I'm trying to understand.
I cannot educate you and train you.
Still, the judge stays remarkably calm. He offers the defendant a lawyer, even a jury trial, giving him every fair chance to proceed properly. But the man refuses to move forward until he gets the jurisdiction answer he wants. At this point, the courtroom feels like it's stuck in a frustrating loop of repetition.
It means it has to be like some inter party. Where is inter party at?
I'm going to order that you appear at the courthouse. Where are you parked right now?
I'm in Texas.
You do know your trial is Wednesday, and you have to physically be present in the courthouse. It is not a
Before
Zoom.
we get to trial, I'm trying to figure out the jurisdiction. You just haven't went over to what the jurisdiction is.
Well, if you don't want to submit to the Kansas jurisdiction for your live trial on Wednesday, I can get you a warrant, and you can be brought before the court.
I'm appearing in person right now. I'm doing my duty to appear, but you're not telling me.
We're not having a Zoom jury trial.
They're not telling me. You're not telling me which. You're not even telling me what the nature of the cause. You're not telling me. You're not even telling me if it's common law. If it's common law, then
Eventually, the judge calls it what it is: games. He's answered the same question repeatedly, but the defendant won't accept it. This is a typical sovereign citizen playbook. Stall, confuse, and pretend the court doesn't exist. Judges can only take so much before they have to put their foot down.
cause of nature of the
Sir,
matter.
I'm going to find you in contempt if you keep talking over me and being disrespectful.
Ma'am, you keep not even answering my question before you
All
let the jury
right,
trial. You just
okay.
letting it.
You are now found in contempt.
That's it.
We will deal with your consequences Wednesday at the jury trial. This is set for jury trial. It's going to cost the taxpayers some money, so you better make sure you're ready to go to jury trial come Wednesday. You better make sure you're not in Texas. You better make sure you're sitting in the courtroom in Greenwood County, Kansas. That's Eureka, Kansas. Do you understand?
That's when things start to escalate. The judge threatens a warrant and finds the defendant in contempt. Even then, the man keeps asking, "Where's the injured party?" The truth is simple. Driving without a license doesn't require a victim. The real victim here is the rule of law itself.
Your Honor, I still have a question. You still haven't answered my question before you dismiss. I
And
asked
I
you which
told
law
you, sir, I am
granted.
not.
Under the Sixth Amendment, right? Under the Sixth Amendment, you have the
Okay, I'm
opportunity
going
to
to fine you. I'm only going to fine you $50 for that first contempt.
$50 for what? What don't
For
understand?
continuing to ask the same questions over and over after.
I'm asking it. You never answered it. You never told me which.
I'm going to object.
Which
It's been asked and
jurisdiction it was.
answered. It's been ruled on, Judge. We need to proceed to the next step. The state has taken the opportunity to glance through the case Mr. Patterson cited. It can be distinguished from this case because the ruling says the person has to be subjected to up to 12 months imprisonment. It is a DUI case where someone was convicted of a first-time DUI and they were subject to 12 months of prison time or jail time under the law. This is a Class B non-person misdemeanor that's 6 months or less. It must be greater than 6 months in order for the person to be subject to an automatic jury trial. Otherwise, lacking the request, it may be a trial to the bench under the case law. So therefore, the State v. Jones did not apply in this matter. He is facing no more than up to 6 months. So the automatic requirement for jury trial does not apply in this case to Mr. Curvin. The request for jury trial would still need to be in writing for a matter that's up to 6 months. And therefore, I would ask that we don't waste a jury's time and have a bench trial on Wednesday. And move forward in the case.
Mr. Curvin, do you want a jury trial or a bench trial?
I want a jury.
What we've just witnessed isn't a real legal defense. It's self-sabotage disguised as confidence. Courts run on rules, facts, and legitimate law, not on loopholes or internet fantasies. And in the end, all this defendant managed to earn was a contempt charge and a jury trial that's almost certain to end badly for him.